Ready? Start. Wife is living separately for more than a year. Stop. Thus, the subsequent shoot number 214 of 2008 for divorce was filed after about 1 year of institution of original shoot number 238. Stop. There has been specific pleading and evidence adduced by the petitioner husband that his wife respondent lived together only for about 2 weeks till February 2005. Stop. There is no evidence on record that parties had lived together after February 2005. Stop. It was the OP respondent within bracket wife who had pleaded that she had been living together with her husband from the time of marriage till 2008. Stop. But there is no evidence or proof of it. Stop. Stanza. It is true that the plaintiff had averred in the plaint that the defendant was closely related to her and she had entrusted the management of the scheduled land to him, and on his request she had leased the shoot land to him in the year 1971 and he had paid the rent by way of share. Stop. But the plaintiff further specifically alleged that the defendant had denied her little and claimed title in herself, and he had also denied the relationship of landlord and tenant, and therefore the defendant was a trespasser and she was entitled to sue for possession to evict the trespasser. Stop. The averments relating to defendant earlier being the tenant furnish the factual background leading to the cause of action for the suit. Stop. The averments in the plaint should be read as a whole. Stop. If so done, it is clear that plaintiff claims that defendant is a trespasser in the shoot land. Stop. Significantly, the defendant in his written statement did not allege that he was the cultivating tenant of the shoot land. Stop. Stanza. On the other hand, he denied the title of a plaintiff and asserted ownership and title in himself by adverse possession, alleging that he was in occupation of the shoot property since 1957 in his own right. Stop. He categorically stated that plaintiff was never his landlord. Stop. Neither plaintiff nor defendant claimed or admitted that there was relationship of landlord and agricultural tenant. Stop. To repeat, plaintiff's case was that the defendant was a trespasser. Stop. Consequently, tenancy was not an issue in the shoot. Stop. Section 13 requires an application to be made to the special officer under the Act only when a landlord wants to terminate the tenancy and evict his cultivating tenant and not otherwise. Stop. When plaintiff's case is that the defendant is a trespasser and the case of defendant is that he was the owner and he was never a tenant of the shoot land either under plaintiff or anyone else, the shoot was not for eviction of an agricultural tenant and therefore section 13 of the act was not attracted. Stop. Stanza. The appellant defendant contended that as he had denied the title of the plaintiff, the case would squarely fall under section 13 within bracket E of the act. Stop. He submitted that section 13 within bracket E contemplated termination of tenancy and filing of an eviction petition against the cultivating tenant if the cultivating tenant willfully denies the landlord's title to the land, and therefore the remedy of the landlord was to terminate the tenancy and seek eviction of the cultivating tenant by making an application under section 13 within bracket E of the act, and a civil suit was not maintainable. Stop. Termination of tenancy and eviction petition under section 13 within bracket E are contemplated only where the defendant is the cultivating tenant and the defendant willfully denies the landlord's title to the land. Stop. In this case, the defendant denied that he was the cultivating tenant of the shoot land and plaintiff claimed that defendant was a trespasser. Stop. Hence, the first requirement for application of section 13 within bracket E was not satisfied. Stop. Stanza. If the case of plaintiff had been that the defendant was the cultivating tenant under her and that defendant was claiming to be the cultivating tenant under someone else by setting up title in someone other than the plaintiff landlord, section 13 within bracket E would have certainly been attracted stop. In this case, as noticed above, the plaintiff alleged she was the owner and the defendant was a trespasser stop. The defendant asserted that he was the owner by adverse possession and denied that he was a cultivating tenant at any point of time stop. When neither party to the suit claimed that defendant was the cultivating tenant and as the suit was not for eviction of a cultivating tenant, the mere denial of the title of the plaintiff by the defendant in respect of an agricultural land would not mean that only the authorities under the act will have jurisdiction and that plaintiff should sue for eviction under the act by approaching the special officer stop stanza. After serving for 16 years, the petitioner number 1 was declared medically unfit for all categories in the railways due to 100% loss of her vision and consequently wide office order dated 24/8/2000. She was discharged from railway services with effect from 14/7/2000 stop. At the time of her medical disablement, she had about 4 years left to serve before superannuation stop. Her son Ashok Kumar, petitioner number 2, applied for compassionate appointment claiming a right to be appointed on the disablement of her mother in terms of the Master Circular dated 12/12/1994 appointment on compassionate grounds issued by the Government of India Ministry of Railways stop. The application was accompanied by an affidavit of petitioner number 1 stating that her son was her only support, especially as she had lost her eyesight. However, he was unemployed and the family had to incur heavy medical expenses for her treatment before she was discharged from railway service stop. She submitted 2 more representations dated 10/8/2001 and 13/8/2001 stop. Her request was rejected by the letter dated 5/10/2001 on the ground that the financial conditions did not represent that she was indigent stop stanza. The petitioners filed original application number 157 of 2002 stop. The Central Administrative Bench, Allahabad allowed the original application wide judgment dated 9/11/2004 and while setting aside the order dated 5/10/2001 directed the respondents to reconsider the case of compassionate appointment to petitioner number 2 stop. The tribunal found that while considering the case of appointment on compassionate grounds, the authorities cannot take into consideration the retirement termination benefits given to the family of the deceased stop. The monthly pension of petitioner number 1 should also not to be taken into consideration while considering the financial status of the applicant's stop. The tribunal also recorded a finding that the possession of 1 bigha and 5 biswas agricultural land is too small to yield sufficient produce to sustain the family stop. The third ground that she had major son who is dependent on petitioner number 1 and the services at her credit was only 2 years and 9 months before retirement also could not be the ground to reject her application stop. In the tribunal's judgment dated 9/11/2004, an observation has been made about 7 cases for grant of compassionate appointment to the defendant medically unfit persons stop. Out of these, in 2 cases, there was only 28 days left in the employment stop. The facts and circumstances in which compassionate appointment was given in those cases were not presented before the tribunal stop. In the absence of the relevant information, the petitioner's case cannot be considered favorably only on the ground that the dependents of 7 stop over.